Welcome to this week's episode of On Record PR. If you are a regular listener of the show, welcome back this week. And in case you are joining us for the first time, I am Jennifer Simpson Carr, and I'm here with
Gina Rubel.
Hi, Gina.
Hello. Good morning, Jennifer.
So today is Monday, May 19th, and we are diving into one of the most sensitive and high stakes areas of law firm PR, communications during a major litigation. So we know that whether you are defending a global brand in a regulatory matter, navigating a class action lawsuit, or representing a high profile client in a precedent setting case, your reputation and the reputation of your firm can be on trial too. So in this episode, Gina and I are going to talk about critical moments in litigation communications, what firms often get right, where there's opportunities to improve, and how to protect both your legal position and your public reputation, and also that of your clients when the stakes are high and oftentimes the spotlight is on. So, Gina, let's dive right in. Why does early engagement matter?
So when there's opportunity for a law firm to talk to their in-house comms people or their outside comms people, depending on the size of the firm, it's really important that the earlier the better. And the reason for that, Jen, is that it allows us to look at the risks. It allows us to evaluate the media. What is their position in this type of case? Let's think, for example, environmental contamination. You want to make sure that the media is aware, you know who to talk to and who not to talk to. You also, and I just have to say this for the lawyers listening, you do want to be mindful of the rules of ethics always. So I don't want to forget to say that. But at this stage, at an early stage, you're really just evaluating what facts do we have? What don't we want to draw attention to? What is the court of public opinion thinking about that? And is there opportunity to frame the narrative? So the earlier the better. And if you think about it, it's like an insurance policy. You're planning for what might be, what might happen, and you may settle and you may end up with confidentiality agreements that it's never going to be talked to in the court of public opinion, and that's okay too. But the earlier you have those conversations, the better.
So that's really important and helpful because one of the most common oversights we see is waiting too long to bring in communication support. And oftentimes it's because we hear attorneys say, oh, we don't have all the facts yet. We don't want to draw attention to the case. So that makes a lot of sense. Let's get to the next point, which is getting the message right. So in litigation communications and trial publicity, oftentimes nuance is everything. You mentioned environmental matters. Oftentimes those types of issues have really complex facts that are difficult for anyone to really communicate pretty easily to the general public or to the media. So how can firms and their clients strike the right balance between legal precision and helping ensure public clarity when developing messages around these litigation matters?
And for those watching, I'm looking for something for a quick second. Here it is. So it's interesting, Jen, because I'm reading Terry Sussblatt's book. I'm showing it to those of you who are watching on video, but for those of you listening, it's called Say It Well, Find Your Voice, Speak Your Mind, Inspire Any Audience. And he was a speechwriter for Barack Obama. And the reason why I'm bringing up his book, and hopefully we'll have him on the podcast very soon, but he has a whole section on talk like a human. And it's so interesting you just said that because I just finished this chapter and it's about talking to the people. And what I like to say to lawyers is when you're talking to the media, you're talking to the general public. And it's the same thing as when we learned in law school to speak to the jury. So you don't want to use jargon, complex language, legalese. You want to make it easy for people to understand. And what's in the reason why I mentioned Terry's book is in chapter 9, he just really hits it home. Like be gone or double negatives, use positive language. And I just love the way he positions it. So I want to give him a shout out for that. But it's really important to remember, even in something like environmental litigation or complex injury cases, anything when you're talking about healthcare. Oftentimes we as lawyers are, when we're talking to experts, we have to use very complex terminology. Think about the doctor's appointment when the doctor talks about, think about it this way. You have a kid and they say, oh, your child has conjunctivitis. Like, huh? They have pink eye, right? It's so speaking in everyday language is really going to help to get the message right and also know who the audience is. So you're going to develop a core message as a law firm getting ready to litigate based on the likely scenarios. If it's settled, if it doesn't settle, if it, how it could play out. Ensuring that those messages align with the legal arguments without getting too confusing. You talk to the general public. And I want to put a caveat in there. If your goal is to only speak to the legal media, it's okay to be a little bit more specific with legal language, but also make sure that the reporter understands what you're talking about. So if you're going to be pitching a new reporter who's just started the legal beat, you're probably going to want to speak in, and let's say they don't have a JD, they don't have that experience. You want to make sure they can understand. And then you want to prepare both internal and external messaging and anyone who's going to speak on behalf of the firm or their client. So there's a lot of opportunity here to get it right and to be able to explain why this is important to the audience that you're speaking to. Does that get to the core of what you were trying to ask, Jen?
Yes, absolutely. And I think the scenario piece also talks to the planning ahead, which you mentioned earlier, so that you can map out the likely scenarios and be at the ready with potential next steps and messaging rather than being reactive when the next step happens. So absolutely.
And I should mention, it's also, there are times where saying nothing is the best strategy, but please never say no comment. Saying no comment always gets you in trouble.
It's funny because when I hear no comment now, I always envision you saying no comment is the equivalent of a lawyer running down the courthouse steps with a briefcase next to their face. So
that's a great example, Jen, of how using visuals in your language, something that people can see and relate to. I've said that for years. I feel like I'm a broken record when I say it, so that's why I don't say it anymore. But it's funny that you said that because it just reminds me that that visual lasted for that long.
And you also, I just want to mention to our listeners, you had a great interview a few seasons ago with Phil Goldberg, who's the managing partner of Shook, Hardy and Bacon, about the power of compelling narrative and litigation. So we are going to drop the link to that episode in this show notes because I do think it's really relevant to the conversation we're having today.
Good point. And Phil was great to talk to.
So last point we want to hit today is media and public engagement in real time. So the media is 24/7, 365. We know it does not stop at this point. And in the case of a litigation, a high profile matter, let's talk about, the point in time where the news breaks and it's a moment when many firms realize how prepared or unfortunately maybe underprepared they are. What are the key characteristics of a solid litigation communications plan so when that moment strikes, law firms are ready?
Well, it's interesting. A litigation communications plan is very similar to a crisis or incident response plan. So the very first thing you want to have is who is your rapid response team. You need to know who can speak, who cannot speak on behalf of the client. Some clients only want their legal counsel to speak. Others say it will be our CEO. And that's something that should be determined early on. And it really does matter who speaks. It should never be a PR or crisis firm. And that is just, that's a no. In fact, Jen, we have that in our contracts that we'll never serve as a spokesperson.
And
Um,
can you talk for just a minute about why that is? Because I think it's a really interesting point, and it's a question we do have to answer pretty frequently.
that's interesting because A, it's not our case, and B, it creates a perception that they're hiding something. They're talking through their PR team. They're talking through their crisis team. And then I've seen it happen where the media has said, oh, their crisis communications consultant said X. Well, now you've created a situation that's a crisis rather than actually speaking with integrity on behalf of the client and or your company, or it could be a family too. I mean, this isn't just corporate. We've done all sorts of high profile litigation. Some are where there have been many people who have been sexually assaulted at summer camps. Others are, high profile chemical cases. So one, if you're talking about individuals being harmed, when it's the family speaking, there's a much greater impact than the lawyer. When you're talking about complex issues, let's say immigration, which we're seeing a lot in the news now, the only people who can speak are the lawyers, right? And then when you're talking about potentially, let's say a chemical spill or something like that, it might, if it's a chemical spill, for example, the CEO of the company needs to take ownership and speak up, even if there's going to be litigation. And that's where what's interesting is the lawyers and the PR people have to communicate early and have to really align, because there are differing interests between the court of law and the court of public opinion. And so that's where it's really opportune to know who's going to be speaking on behalf of the issues, when and why. Because then you're going to be fighting, let's say it's a chemical spill, then the people who are going to get a lot of media attention are the environmentalists, the activists. And so knowing what they're going to say and how to not necessarily rebut it, but how to get your most salient point across are going to be important. So having a PR firm or a crisis person speak on behalf of your client does nothing for the client. Our job is to be behind the scenes. We're the set directors. We're the ones who are doing the research and saying, here's how this phraseology in your complaint or in your response will be heard by the court of public opinion. If you say it this way instead, it could have a different impact. Mm-hmm. So I hope that answers the question.
It does.
So we started about the media response team. I just want to repeat, your question was, how should they prepare? What are the characteristics of solid litigation communications plans? So the first is that response team. The second is, how are you going to respond to media inquiries? There are points in litigation where you should not be responding. It's active litigation. So it may be that you're just speaking on background to a reporter and saying, here's what's happening. Here's what the process is going to look like. Here are the key issues in the case. I can't speak on the evidence. But I can speak on background. And before you ever speak on background, and I'm pretty sure we have a podcast, probably our very first one with Gina Passarella, Cipriani, about the different kind of language that's used in media interviews. And so what's on the record, off the record, on background, all of that. So Jen, we should probably link to some of those things as well in the show notes. And then you absolutely need tools to monitor how the story is evolving, and online or in the press are all the same. You know, I mean, today we have citizen journalists, and, you know, we handled one case that I can't speak about where it was a citizen journalist who broke news on YouTube and made our clients' lives very difficult. I'll just leave it there. So, and I can't speak about it because we're under NDA, which is usually the case.
Mm-hmm.
So, and there are a lot of tools. I mean, you're familiar with most of the tools we use, Meltwater. So for example, right now we're monitoring a case that's beginning today, and I'm getting hourly alerts on anything coming out of the media. And there are so many of them. In fact, next month, I'll be publishing an article on those tools, but I think we have some resources on our website as well. We use Meltwater. There's many others. There's Critical Mention, there's Cision, there's, my gosh, there's just so many. But it's important to know how you're monitoring the news, what's being said. And frankly, I'm often just online doing searches as well, because sometimes your monitoring tools don't pick things up as quickly as I might want to see something, like the minute it's published. So if I know, for example, law.com or Law 360 or Reuters is going to be publishing something, or that they've spoken to one of our clients, I'm probably checking it constantly. And I literally mean I have it open on my screen and I'm hitting refresh a lot, kind of like OCD. But that's what I do. And I'm checking, you know, we're checking social media, although the nice thing with a Meltwater or a Critical Mention, they're picking up the social media chatter as well.
So social media has become a really big part of the way humans receive information. And we're learning more and more about certain generations using it as a search platform, right? Going into Instagram or others and actually searching for news and information. So can you just talk briefly about the risks and or opportunities that exist through these platforms as it relates to the litigation we're talking about?
Well, there's definitely both risks and opportunities. For example, we've helped some firms correct false narratives, protecting themselves from organized attacks, humanizing their clients, and engaging with communities, all while staying in the bounds that are legal and ethical. So a good example of that is during the 2016 election. I'm sorry, I'm like 2016. Wow, it's almost 10 years ago. We had a client that was politically attacked by one of the by followers of one of the candidates who dropped out of the race. But it was really ugly, and we had to make sure that we stayed on top of it. And that was a case where it could lead to litigation. So it wasn't necessarily litigation per se, but it could lead to litigation. And we had to be really careful. And in that instance, we told our client and their constituents not to engage. Don't engage at all. Stay quiet. It's going to play out. Do not respond. Within a few days, there will be another story, somebody else they will go after. But if you feed that animal, and I say that in really, it's like in my mom's old neighborhood, my best friend just moved in there, and there's a fox, and the fox comes out every day between 4 and 6. And it turns out that people are feeding the animal. So the animal comes back every day for food, right? So it's this great analogy. When you think about online social media, the more you feed it, the more people will keep going. And the more the algorithms will pick it up. So that there's times where you don't want to feed it at all. And you just stop talking, be quiet. I also tell our clients, don't look at social media because people are nasty. They will say the worst things. They will tell lies. They will create, I mean, now with generative AI, they can create fake images and the things that are out there, it's pretty scary. In fact, this morning before we got on, I was reading the United States Supreme Court opinion from last week in that deals with the Venezuelan immigrants here in the US that the administration wants to deport. And I was reading the opinion because I've seen so much media coverage on it and nobody got it right. And I wanted to read the opinion to find out what they actually said. Because people were like, oh, the Supreme Court upheld, or they said this. And for purposes of headlines, we have gotten lazy as a world. I say it myself, like I tend to read headlines and if the headline doesn't catch my attention, I don't read any further. Well, that's the same thing with social media. The very first statement is the headline and if it resonates, people will read further. But oftentimes people believe only the headline and don't read any of the details. So social media is one of those places where you really do need to be careful.
So I think we're at the end of our time together, but to quickly recap, it sounds like the focus of our conversation today is really to have a plan in place, no matter if it's potential litigation, but really to have a plan in place and to bring in your communications teams early. And when we say communications teams, that's your in-house team members, it could be agency partners, but the professionals that you rely on to bring that perspective. So thank you to our listeners for joining us today. If you found this episode helpful, please subscribe and share it with your colleagues and consider leaving a review on iTunes. We very much appreciate those. We also appreciate the feedback and ideas you continue to share. If you have some, please send them to us at podcast@onrecordpr.com, and we will see you again next week.
Take care, everyone.
This episode is brought to you by Furia Rubel Communications, a public relations and marketing agency serving law firms and businesses worldwide. With an expert team positioned throughout the U.S. and supported by an international faculty, Furia Rubel enhances our clients' brands through integrated communications by providing expert guidance in crisis management and high-profile litigation, protecting brand and reputation, and supporting internal marketing teams. To learn more, visit furiarubel.com. On Record PR is produced by Jennifer Simpson Carr and Matt Henderson, with support from the team at Furia Rubel Communications. This episode is edited by Isabel Horan and Christian Yamula. Visit www.onrecordpr.com for resources and more information.